My name is AMARJOT Singh. I'm an immigration consultant based in Alberta, Canada. And a lot of people asking me questions about how to go to Canada on a PR, study visa, tourist visa, and other schemes, whatever possible for them. But there is a general notion among people that if they cannot qualify as a direct PR, perhaps they can get a tourist visa and then they can come here. Is that the question that you have? Pankaj is on the line from Muscat. Pankaj, is that more or less the question? What is the question?
Yes, definitely, sir. This is the question that I've heard that people who are not successful in getting PR, then they reach there on a tourist visa, and after that they make some arrangements or try to be successful in PR. So is that possible? I just wanted to clarify this.
Yeah, let me just show you through a case. I have a perfect case for you and for other people who are listening to this answer. I will explain the answer through this case. And what I do is I study court cases of immigration law sometimes, and when the case arises, when the question arises something like this, then I look up a case, and I'm here to present you a case that will give an answer to this question, and then you will see. Can you see my screen?
Yes, definitely, I can see your screen.
Good. Uh, Briefly, this case is about a person who was in a similar situation. He came to Canada on a visitor visa, and then while he was here on the visitor visa, he was maybe since from the start searching for a job, and then he applied for a job. He got a job. He got the LMIA. Then he applied, to get the work permit by going to the border. On the border, there was something. Then I'll show you in the case what happened. He was refused, and then actually he was deported. So sometimes these kind of schemes of getting converted into a regular status, into a PR status or change of status, sometimes they are successful, other times they are not. You have to be very careful how do we do this. So let's dive into the case quickly, and then go from there and see what happens. Can you see my screen?
Yes, I can see your screen.
All right, so this is under the series called misrepresentation. I make a lot of collection of cases, and this is under series called misrepresentation. The case is called Singh versus Canada, and anybody who's interested, they can copy and paste this link, and then I will also post this link at the below at the screen, and then you can go to this screen and then actually read the case on your own. And this was in the Federal Court of Canada, somewhere in the Toronto area. But let's see what happens step by step. You can see my screen, right? Just let me know, Pankaj, if you cannot see my screen.
Yes, I'm able to see your screen, sir.
Good.
It's fine. It's clear.
Good. So December 25th, 2017, the applicant arrives in Canada on TRV. I've done some lot of homework and research on this. As you can see, I've made a special, tabulated chart to explain to people. And what was the purpose? What was the purpose of this gentleman to come here? He came here. He wrote in the application form that I have to spend time with the family. So the TRV application at that time from India, or we are not sure whether he was hiding the case at the time of application of TRV visa or at the time of extension. He hid the information that he had welding education and employment experience. So we do not know. And of course, you will see in the court case that the counsel actually mentioned this. This is a possible hiding of facts, just like other things. So he came on December 25th, 2017, and after about 5 months, the visa is normally given for 6 months. After 5 months, he applied for extension of visitor visa. Do you see that?
Yes, I can see that.
Are you able to follow my sequence?
Yes, definitely. It's a very good homework you have done. I really like it.
Thank you very much. Thank you. So after about 5 months, he applies for extension of the visitor visa status. And what is the reason he writes here? I'm here to spend more time with the family. The application was extended again another 6 months, which is till November 30th, 2000. So you can see the sequence all the way from December till 2018. All right, good. So while this application was being processed, and not only processed, was finally processed on around 15 October or so. Maybe he was searching for the job earlier, but on around 15 October 2018, He applies for a job. I will not disclose the name of the, but that name is listed on the court case. He applies for the job. He gets a job, and he gets the job on the same day on which the job was offered. He gets a job as a welder. So he was a welder earlier, and he gets a job as a welder. He is also aware, so I'm going by sequence. This is sequence number 4. So he's aware that the LMIA is needed to convert the visitor status into work permit. So he's aware that's okay. Now, on February 2019, what happens after about October, November, December, January, February, about four months, he again extends his visitor status with the help of an immigration consultant. What does he write in that extension again? So this is the second extension. So what does he write in the extension? His purpose was, I'm here to visit and spend time for the family. He never mentions in that application form that he is actually been offered a job, or he is applying for a LMIA, or LMIA application has already been, the process has started. So he has hiding all this information. So nothing was mentioned. All right. Are you with me, Pankaj, so far?
Yes. Good. Right. Very good.
Good. So after 1 month, or so, after 1 month of the visitor visa, number 6, the LMIA is approved on March 12, 2019. And at the same time, after about 12 days, he also gets a letter from the immigration that his existing visitor visa status has also been extended for another 6 months till August 6, 2019. So the visitor visa is now extended, and also his LMI is also was approved in March. So he's ready. So he's got the visitor visa status already, visitor status in Canada. So he's already have the LMIA. So now he's ready to, get the work permit. Also. I think there's I think on March 12, the LMIA was approved, but it was possibly in April. Number 8, possibly in April, the employer tells him that LMIA is approved, and that's how he knows. So after about 1 month or so, we do not know what date in April, but on May 2nd, he goes to the border. He goes to the US-Canada border, which is Niagara Falls and Rainbow Bridge. What was the purpose? To obtain a work permit. It's called flag polling. So you can do a search on flag polling on Google, and then you can see what flag polling is. That means what you do is go to the border. They have the Canada immigration people sitting there, and they say, hey, why are you here? And say, look, this is my LMIA, this is my visitor status. Can I get my work permit? So that's what happens. But CBSA finds him inadmissible because of misrepresentation, because he was hiding the fact of LMIA application in his earlier visitor visa application. So that is number 9. This happens on May 2nd. On December 19th, of course, he must have been very dejected. So he must have come back in May on that day, and he must have consulted some lawyers or immigration consultant, and they must have said, look, we can challenge this in Immigration Refugee Board, which is immigration division. And on December 19th, there was a hearing in front of a member, which is like a quasi judge of the board, and then the judge decides whether it was misrepresentation or not. Did you really hide this? Why did you hide this? Blah blah blah. And they look at all those factors, and all these factors and all these things are given here in the court case. Can you see my next screen?
Yes, I can see that.
This is the entire 14-page. It tells you exactly what questions were asked and pretty much everything. But I will run through the sequence here, and then I'll go to the main case.
This is a very nice synopsis. Yeah,
that's right. So the hearing was conducted on December 19th, and the applicant. So there are two parties now. The applicant may be represented by his lawyer, and the opposite side is the government counsel who says, look, you have misrepresented, and the applicant says, no, I have not misrepresented, and the judge, the third party, he looks at both the situation, and they decide what is right and what is wrong according to law. So the applicant is claiming, look, I did not have to disclose. The applicant says, look, even though I was filing for visitor visa application, I never had to disclose the LMIA application. That's what he said. But nonetheless, the member of the immigration board decides that no, you didn't misrepresent, and what happens? They issue an exclusion order, which is like a removal order, and you are banned for 5 years because you lied, and you're banned for 5 years, and that's all it is. So after this happened typically in on the same day, December 19, 2019, and after close to about 6 months or 8 months, he must have quickly filed for judicial review. Point number 11, and the judicial review hearing was scheduled and heard on August 31st, 2021. So it took about a long time. It's not easy. Sometimes people say, hey, let's go to the court and get this hearing. I mean, sometimes the hearing also is not, the dates are not available. And this possibly happened, in the COVID time in 2020. So the date actually was conducted, was issued and conducted in August 31st, 2021. The judicial review, now this is a judicial review. That means now a federal court judge is listening to the facts. So earlier, the Immigration Refugee Board had said, no, sorry, you have misrepresented. You were hiding a lot of your intent to work here. And, I find that you are inadmissible. I will bar you 5 years. You're deported. You should go back to India for 5 years. Now it is to the judge to decide, the federal court judge to decide whether the immigration ruling itself was valid and acceptable or not. So here's again item number 1. As you can see, I've done a lot of homework and research about this so that people can understand in layman's term what he said, she said. So the applicant says in his application is, hey, my main purpose was to spend family time, but job search was secondary. All right, so that means I'm here to meet my family, but job search, if I get a job search, that's a secondary purpose. That's not my primary purpose. And I've given a number here, but I'll show you the number, paragraph number 27. It's somewhere here. Is it here? And I've made some notes here. Can you see my Pankaj? Can you see my screen?
Yes, I can see that screen and the notes also in the red font.
Yes. So I'm jumping directly to paragraph number 27. First, the applicant claims that he inaccurately indicated on the visitor visa extension that he intended purpose was spend over time. The applicant then adds that his main purpose of extending was to remain with his family, but a secondary, less compelling purpose was to see if there's a job available, if somebody can hire him. And I wrote my notes, and this is my notes. All right, in red. I think he's lying. His purpose was all the way through job search. So many people from India and other countries, they think, hey, look, I have a tourist visa. Let me go there, sneak in as a family visit, and then search for jobs, and then get an LMI and get a work permit. This sometimes backfires. I hope I'm coming to the answer to the question what you asked. I mean, sometimes we come on a tourist visa. We do not tell the airport immigration that, hey, look, I'm here for a job search. I'm not here to visit my mom and my fiance and my friend, something. My main purpose is job search, and there's nothing wrong with it. But if you hide it, then there's sort of problem. All right. So let me go back to that's 27. Look at point number 2. So what the applicant says is, look, Act 40, which is Immigration, Refugee and Protection Act, does not compel applicants to disclose all information. So what I'm saying is, look, I'm not supposed to tell you that I'm looking for a job. This is what it's saying. The Immigration Refugee Protection Act only aims at assessment for the primary and the most compelling purpose of visit. I mean, not the secondary purpose. Do you understand, Pankaj, so far?
Yes, it's good.
So the applicant is saying, look, your application form for visitor visa extension is asking what is the main purpose of being here, not the secondary purpose. And it is not incumbent on me to tell you everything about my life. Why should I tell you for a job? This is what he's saying. And the judge says, no. It is not for you to decide what is relevant or not. It is for the immigration to decide. And that's in paragraph number 29. I'll show you here. Here. The applicant goes on to suggest that the paragraph 40 of IRPA does not require spontaneous disclosure of all information that might be possibly relevant. He further argues that Parliament could have only intended for applicants to be assessed for the primary and most compelling purpose. I disagree. Look, and the judge says, I disagree with your logic. And I wrote also, this is what I'm writing about the applicant. I think your thinking is wrong and presumptuous. You cannot decide in advance what the immigration is intending with that information. It's your duty to disclose everything and let them decide whether we want this information or not. So I'm jumping back to point number 3. The applicant says, look, judge, honestly, look, felt I'm not required to disclose all the possible job offer LMIE. In addition, I was not even familiar with the process and specifics. It was blame the immigration consultant who's responsible. And now the first logic is not successful. Then say, look, I am sorry. I am not very educated. I'm not very informed. It's the immigration consultant who was giving me advice. So this is what he says here in paragraph number 33. I will show you in paragraph number 33. Where is paragraph? Yeah, here it is. And he says here that it was, here it is. He says that it was the immigration consultant who completed the application. So if nothing else works, blame the lawyer. You know, if I'm naive, if I made a mistake, hey, I did not know. It is the immigration consultant who did this. So, you know, they're trying to play that game of, you know, it's the immigration consultant who did the mistake. But the judge says, look, it does not matter whether you have knowledge or not. You are responsible for the application contents. And, you know, he gives certain examples of certain cases, which I don't have time to go into this right now. But in previous cases, it was decided whether you are uneducated or whether you have low English or whether you don't understand the legal terms of the application. When you sign the application, you are responsible, not the immigration consultant. So that's what the judge says. All right, so that's it. And if the applicant had disclosed the job application, he would have. Yeah, so it is the judge also added that if you had disclosed all your information about your job cert, it is very possible that you would not have gotten the second extension. That means the second visitor visa extension, the immigration would have decided, I do not know why you are here. I think you said earlier that you are for family purposes. Now you suddenly said you're for job search. And then it is very possible that you would not have received the second visitor visa extension. Judge also says at the last is, look, if you come to Canada for a visitor visa purpose, that's okay. I mean, and if you want to change your things about whether you want to study or work something, that's okay too. The change is not disallowed, but you have a duty to disclose the change of purpose, and that's what you not did. End of immigration future. Bye bye. Next year, 5 years. I'll see you after 5 years. So. So coming back, I mean, by the way, this is the case. Anybody who wants to read the case, he can go into Google and type this case, and I can also leave a link at the bottom. The reason why I had to use this. Let me just block this off and then come back to you on the camera. Let's see. All right. So the reason why I took this case to explain the nuances of the answer to your question is, a lot of people think that if they cannot get express entry, if they cannot get LMIE, if they cannot get anything straightforward, they should sneak into Canada through a visitor visa. And once they come to visitor visa on a status here in Canada, they can easily maybe manipulate something, maybe find a job, get admission, and change the purpose. Immediately change to student status, or change to work status, or get married or something, or apply for humanitarian, apply for refugee. What I'm saying through this question of yours is that is wrong. As the judge said, look, you can change your category, but as long as you do not hide, you were applying for visitor visa extension, but you were hiding all the time that you were applying for the job and you already got a LMIA. This is wrong, and we will penalize you by giving you a removal order. And this is what I had to use this case to describe. You can do anything on a visitor visa, but do not hide anything. That's all I have to say. Any questions?
So had he disclosed at the time of second extension, had he disclosed the right purpose that he got the LMIA, he would have been in a better position today.
Absolutely. And not only better position, I would have argued that he would have actually also got the work permit successfully, because it is not wrong to search for a job. It is not wrong to look for a job. It is not wrong to take a job interview. But if you could have just mentioned on the second visitor visa application, look, I'm here to visit my family. My family is here. I'm being taken care of. My food, boarding, lodging is covered. I have money to stay here for longer. But by the way, I attended a job interview and I was offered a job, and LMIA is also, is successful. I have the LMIA. I want to get additional time, maybe 3 months, 4 months, 6 months time to enable me to convert from visitor status to work permit status. Nothing wrong with it. Maximum loss could have been if it, look, the worst come worst situation, if it was refused, if the second visitor visa application was refused, he could have easily left Canada, went back to India, and then he could have applied for a work visa from there. But at least he would have been successful either way, because he was truthful in that application, and that would have meant, you know, maintenance of that credibility. Because once you lose credibility with immigration, you are done. Your chapter is over.
Actually, that was I was about to ask the same thing. Had he gone back before the second extension, then he would have been able to come back. So you already answered. Yeah, you already answered that question too.
Absolutely, I have no doubt. I have personal examples of, I've done some applications where I have listed. I'll tell you some other example if you have interest in immigration law. In one of the visitor visa extension application, I listed there that my client wants to get 6 more months. Why? Because he is in a relationship. He will get married after 3 months or 4 months. And why after 3 months? Because right now he does not have the money. But he wants to plan ahead. He wants to do some arrangement and other things and invite friends and something. So, hey, by the way, I want to get an extension. We will get married after 3 months. And after marriage, I plan to file a spousal sponsorship leading to PR. So my intention is clear all the way. And lo and behold, we got the extension because I have nothing to hide. Not only extension, but when the time comes for spousal sponsorship, they can see the track record of the communication and how it was building up. So everything went out very, very nice. I'm very dreadful of a lot of people who are coming from overseas and they cannot get the study visa, or maybe they, they are mature candidates. They are 35 plus, 40 plus, and a lot of consultants in those countries tell them, look, why don't you take the visitor visa? Maybe study visa is difficult for you. Why don't you get the visitor visa? Come to Canada, and then I will convert your visitor visa, study visa. That's the same scenario as we just saw. As soon as you get the visitor visa and you come here, and all of a sudden after 1 month or so, then you convert into study visa, study permit status. I think immigration is bound to be suspicious. What was the intention? I mean, were you thinking about study permit all the way along when you applied for visitor visa? How all of a sudden you got the intention of, you have the money, you have the IELTS, and now you got the admission, and now you're given an application for study permit. So I think it borders on misrepresentation. That's why I don't like hiding. I mean, if somebody has to apply for study permit status, when you apply for visitor visa in your country, tell them, look, I'm applying for visitor visa status because I do not know what Canada is. I will go to Canada, I will visit some college or university, then I will decide maybe I want to become a student, perhaps not, I'll come back. What's the difference?
Indeed, yes. You got to be honest. Yeah. Understand that, yes.
Hey, thank you very much for your questions and for the chance of explaining the case. And I was looking to use this case to describe my answer so that a lot of other people can also benefit and take advantage of this case. All right. Thank you very much for your time.
Thanks to you also for educating us.